the title of my presentation is Slapping Judges into Silence, which is a part of my PhD project, which focus on slaps in a context of Poland and Hungary, and is supervised by Professor Gabor Halmai. And today in my presentation, I will focus on some cases, slap cases against judges in Poland. So first, to start with explaining what slaps are, and the acronym stands for Strategic Lawsuits and Against Public Participation. And the concept was first introduced by two American academics, George Brink and Penelope Cannon, in the 90s in the US. And here it's, I think, important to underline that the US states were the first places in the world which introduced slap cases. And right now it's pretty much that all states of the US have some stronger or weaker anti-slap laws. For the purpose of defining what slaps are against judges, I selected three main factors. So first of all, they involve a legal action or threat of legal action. Second of all, they are initiated by powerful individuals or organizations and target those who speak out on matters of public interest. Classically, slap cases are usually against journalists, academics, activists, and those who initiate them are corporations, politicians, business people. And the aim of slap case is to introduce a chilling effect and exhaust the victim psychologically and financially. And slappers might also initiate many cases against the same person to magnify the effect. So like to make it even more burdensome for the victim. In Europe, the topic of slaps started to be discussed broadly in 2017 when Maltese investigative journalist Daphne Caruana Galizia has been assassinated. And at the time of her death, Daphne had more than 40 active slap cases against her. It meant for her that she had to appear in court every day, and all of her financial assets has been frozen. Later, as the foundation created by her family inherited her articles, which they kept published, they also inherited at least some of the cases. After her death, three of her sons, who were later awarded Magnitsky Award for their human rights advocacy efforts, started together with civil society organization a campaign which was supposed to bring justice for Daphne, and part of this campaign was to aim to make EU institutions recognize the problem of slaps and address it through legal changes. This led to creation of the anti-slap directive, which was adopted 2 weeks ago. But in my presentation, I won't talk that much about the anti-slap directive, as it won't cover cases against judges, in my opinion. These cases I will talk about right now, so cases like against Tuleya and Żurek. But first of all, I would like to say that, as I said before, usually slaps target journalists, activists, and academics, and we have even some cases where the slappers, so those who initiate this vexatious lawsuits, are judges, because in the end, judges have a significant position in every society and they hold power within the judicial system. So under what circumstances it can happen that actually judge become a victim of a slap? As I said at the beginning, in my PhD project, I look at Poland and Hungary. So I'm looking at the general situation of democratic backsliding in Poland. And what I'm focusing is also the situation in which those slap cases are working and being initiated. So in 21st century, then authoritarian methods of seizing power and targeting democracy differs from what happened 60, 70, 50 years ago. So we do not have coups anymore. And that's not the way it has happened, but rather, as Professor Andras Shayo said in his book Ruling by Cheating, it exactly happens through ruling by cheating. And as he defined it, the illiberal regimes rely on systematic cheating, pretend to satisfy the requirements of the rule of law by following specific rules that seem applicable, but they do so in disregard of the relevant standards or principle of the rule of law. A regime that cheats in its use of the law breaches a promise of truth or authenticity that the underlying norms of the game will be observed. And Professor Łętowska, following this lead, called it etiquette and schwindel, and she defined it as where the mechanism of governing by law for the common good is replaced by the use of tools in the service of political power. And right now, as I will move to the cases of Judges Żurek and Tuleya, I wanted to underline that the cases against them were initiated by the state through the method of legal harassment. Slaps are one of the types of legal harassment, but as I said at the beginning, their aim, they are targeting those who speak out on matters of public interest and introduce a chilling effect and want to exhaust the victim financially and psychologically. So what happened when two judges, Żurek and Tuleya, their cases, I selected them because of the limited time for the presentation, and also those are important cases that reach European Court of Human Rights, and they were cases that in the set of ECHR judgments on the decline of the rule of law in Poland. And to strengthen my argument about the general situation in this that these cases are happening, I will just quote a short sentence from the ECHR judgment in Grzęda versus Poland, another rule of law backsliding judgment from the set of judgments. And the court said that impungent measures have to be seen in the context of the facts of the case. The whole sequence of events in Poland vividly demonstrated that successive judicial reforms has been aimed at weakening judicial independence. So starting with the case of Judge Żurek, first of all, he was a judge of the Krakow Regional Court, ex-spokesperson of this court. He's also ex-member of National Council of the Judiciary, the constitutional body which safeguards the independence of courts and judges, and ex-spokesperson of NCJ. And he voiced criticism about legislative reforms and executive actions weakening judicial independence. And what follows his comments about the rule of law situation in Poland was that there were different measures aimed at, as court put it, intimidating or even silencing the applicant. First of all, the Central Bureau, Anti-Corruption Bureau started an audit of his financial declaration for 17 months. And they extended it to also auditing his wife, and they questioned his parents. Also, the inspection of his work at the Krakow Regional Court ordered by the Ministry of Justice started. He was as well also dismissed from the position as a spokesperson of the Krakow Regional Court, and there was a declassification of his financial declaration ordered by the Minister of Justice. And following the same reasoning as in the case Grzęda versus Poland, the ECHR found that the lack of judicial review of the decision to remove Judge Żurek from the NCJ had breached his right of access to the court. And what is important for discussing this case as SLAP is that also court found that the accumulation of measures taken against Waldemar Żurek, including his dismissal as a spokesperson of regional court, the audit of his financial declarations, and the inspection of his judicial work had been aimed at intimidating him because of the views that he had expressed in defense of the rule of law and judicial independence. In finding these violations, the court emphasized the overall context of successive judicial reforms, which had resulted in the weakening of judicial independence and what has widely been described as the rule of law crisis in Poland. I will summarize, I will come to the conclusions later after discussing also Judge Tuleya case. So starting with Judge Tuleya case, he was the judge of the district court in Warsaw. He's very well known in the judicial community, but also to the public as at large. And he was commenting the rule of law situation in Poland on numerous occasions in different media, and he was also attending special meetings on the Constitution that were discussing the Constitution and the rule of law with the public. And what happened to him was that among the measures taken against him by the state, first of all, the disciplinary chamber lifted his immunity and suspended him from judicial duties. And second of all, he was a victim of preliminary inquiries instituted by the disciplinary officer. So ECHR noted that despite the professional responsibility chamber, which was replaced the disciplinary chamber after the latter was abolished in 2022, Tuleya had committed no criminal offense. The lifting of his immunity has not been overturned, and he continues to face criminal proceedings. Second of all, the ECHR found that the measure taken against Tuleya had called his integrity and reputation into question, as well as preventing him from working for over 2 years, which in turn had a significant impact on his private life. And this constitutes a violation of his right to respect for his private life. And third of all, the court found that the judge's right to freedom of expression has been violated because the lifting of Mr. Tuleya's immunity had been a disguised sanction for his expressing criticism of successive judicial reform and part of a strategy aimed at intimidating or even silencing him for his views. And as the conclusion, I would like to underline why I think, why I recognize the legal action aimed at judges Żurek and Tuleya as slaps. So first of all, both Judge Żurek and Tuleya were targeted with different legal tools, which was initiated by a powerful organization. Secondly, the legal harassment they experience introduced a chilling effect on other judges, as ECHR underlined in the ruling on Żurek case. Undoubtedly, what happened to him had a chilling effect in that they had to have discouraged not only the applicant, but also other judges from participating in public debate. And thirdly, slaps against both judges had financial consequences for them. So Judge Tuleya was suspended from judicial duty, which meant he didn't receive his salary for the 2 years, and Judge Żurek had to participate in financial audit, which also was connected to preparing all of the documents with the support of accountants, for which he had to pay himself. So I will stop here, and thank you very much for listening to my presentation and for your interest in the topic.